that points to other suspects. That fingerprint that was found on the cartridge tray was not a match to Mr. Juniper. It was someone else's fingerprint, and that's on something that is connected to the murder weapon, which is the gun. And so,
does your theory of this case hinge on a notion that the witnesses, that Ms. Rashid and the others, Ming and the others, must have necessarily concocted this story to pin the murders on your client? And the witness that I found most compelling is Rashid. So maybe you can spend some time talking about why she is not to be believed. I mean, it didn't appear to me that she had any dog in this fight. They seemed to know each other, Ms. Rashid and Juniper, and were on friendly terms. And she presented some fairly compelling evidence about what she heard and saw the morning of the murders that ended up lining up pretty consistently with the Commonwealth's theory of the case. So tell me why we shouldn't lend credence to her testimony.
Well, so again, the question is about the jury, and the jury, in assessing her credibility, did not have all of the evidence. There is evidence that impeaches Rashid in the concealed evidence. That includes the timeline evidence. Again, she set the timeline for the Commonwealth's case, and so the evidence that impeaches the timeline also impeaches.
The timeline lined up fairly well with the actual unimpeachable evidence about the sequence of calls that were made to the police and the like. I mean, there's no indication that those were fabricated, right?
I see my time has expired.
You may answer.
If you'd like me to answer that. So the 12:44 p.m. 911 call, the police who responded to it believed that that was a false call. There had been false calls before. The police spoke with the woman who lived underneath Keisha Stevens' apartment, who told them she'd been home all morning and she normally could hear sounds coming from that apartment.
You say it was a false call. Are you saying that they the person who called, I guess it was Ming and his girlfriend, made that up? That they set up your client by placing that call?
Well, the prosecution argued that was Ming's and Bowser. It's not clear who actually made that call.
Whoever it was, I guess you're suggesting that they either were mistaken or they made it up. Which one is it?
Well, also, if it was Ming's and Bowser, as this court noted in its last opinion, they received that information fourth hand. So they received it through Rashid, Ming's, and Murray. Basically, Rashid would have told Murray, Murray would have told Ming's would have told Bowser, and she called the police. So to the extent that the evidence impeaches Rashid, Ming's, and Murray, which it does in this case, it also impeaches the value of that 12:44 p.m. 911 call.
Well, the call came from a convenience store.
That's correct.
What do you make of that?
Well, there are a number of prior statements, again, concealed, where Bowser indicates that she called from her home, and then in...
Well, I'm surprised you didn't bring that when Judge Diaz questions to you about the phone. He was asking you, do you think that factors into your theory that the phone call may have been concocted? And you didn't respond at all. You said, well, that's why I will ask you about the theories in this case. Is Rashid's her credibility questioned in your theory?
Yes. Rashid's credibility is called into question by...
And how? How in your theory?
Well, so there's significant evidence that conflicts with the timeline that Rashid provides. Rashid says that as she's leaving, she hears these 4 gunshots, and the Commonwealth argues those are the shots that killed the victims. But there is a neighbor who lived just under the apartment who didn't hear anything that morning. There are neighbors who saw people coming and going to that apartment during the time that there were supposed to be 4 dead bodies in there, and that the door was supposed to be broken down. There's
well, let's put it this
also...
Based on the evidence at trial, how well did you pin down Rashid on a time when she left the first time? I know she was back and forth, but what would you say in the facts of this case was the time, her testimony?
She testified that she wasn't really keeping track of time, and she was pretty resistant to pinning down an exact time.
I know that, but what's the best time frame and range you got her to say?
So we've stipulated that the prosecution argued at trial that the murders occurred between 10:20 and 12:44 and closer to 10:20, based on Rashid's testimony. I think the defense tried to say something like the events couldn't have taken more than 10 minutes, so they were trying to pin her to 10:30, and she just continued to say, I'm not sure. how long it would have taken. But she describes kind of a pretty quick time there.
If she left at 10:30, then it would be far inconsistent, wouldn't it? Because she said she heard the shots as she was driving away.
That's correct.
That would put it at somewhere around 10:30 to 10:45.
That's correct.
Far from 12:44, which we don't even know who made the call. And then, but I was just wondering how, because the whole point is, it's Brady material. How is it going to focus in your theory of innocence or evidence that would have a different result, or the jury may have a different view of it? So that's basically the timeline. And what about Ming? Anything he said would question what the jury did not hear? Because this is about what they didn't hear.
Right. And so the jury didn't hear any of the timeline evidence that I just described about the neighbors. None of that was told to the jury. But as far as Ming's, the jury was told that Mings left Juniper out of his initial statement to police, but what they weren't told was that Mings and his girlfriend Bowser actually gave 4 accounts to police. Well, first of all, they weren't told that Mings explicitly denied seeing Juniper in that first statement. He didn't just omit him. He was asked directly, did you see anyone else? And he said no. They also weren't told that there were actually 4 concealed accounts from Mings and Bowser, none of which mentioned Juniper. And Mings doesn't mention Juniper for the first time until May, when he's faced, which is several months later, when he's facing his own probation violation issues. And there's, again, concealed notes of a meeting between his girlfriend and the prosecutor in this case, Evans, where Evans writes down the defense attorney's name in Mings's probation violation case, as well as the judge's name. Evans then appears at the hearing for this probation violation. The entire time, it was 4 years, I believe, is resuspended. And then 5 days later, Mings changes his story and for the first time implicates Juniper. And the jury didn't know any of that. And so that would significantly impeach Mings. There are also, I think 8 prior inconsistent statements from Mings and Bowser that were concealed that differ on almost every detail: why he went to that apartment, how many times he went to that apartment, what he saw every time he went to the apartment, when they called 911, how many times they called 911, whether or not he really saw Murray, Jones, and Juniper leaving the apartment. And all of that was concealed from the jury. And what the prosecution argued to the jury in closing was, look at the way that the details of these witnesses' stories line up. It's really important that you look at the details. They said, it's the details. When you assess credibility in your own lives, what do? You look at the details. And when you look at the prior statements that were concealed, the details didn't line up. And they only were made to line up over the course of, as these statements changed. And again, there was evidence that police were telling witnesses what other witnesses had said, were showing witnesses crime scene photos. That's been stipulated too. And so reasonable jurors presented with the evidence about the way that these statements changed over time and the police misconduct in this case would have reasonably doubted whether Mings was telling the truth, and certainly about the most inculpatory part of his story.
Thank you, Ms. Hogan.
Thank you.
Mr. Gallagher?
Good morning, Your Honors, and may it please the Court. I'm Kevin Gallagher, Deputy Solicitor General of the Commonwealth of Virginia. With me is Jordan Minot, Assistant Solicitor General. We're here representing the respondent, Melvin C. Davis. Almost 20 years ago, Keisha Stevens, her brother, her 4-year-old daughter, and her 2-year-old daughter were brutally murdered. Keisha was stabbed, and all 4 were shot repeatedly. A jury heard overwhelming evidence pinpointing petitioner Anthony Juniper as the perpetrator of these 4 horrendous crimes. Most notably, Mr. Juniper.
Was it overwhelming?
Absolutely, it was overwhelming.
Why did you, the Commonwealth, take so much painstaking efforts to hide and not disclose clearly Brady material? If it was that ironclad, why did you spend so much energy in doing that? And for years held it over. You should come with an apology on behalf of the Commonwealth. Tell me that. You start off with that it was so strong. Why did you take so much time to hide it? Hide it. You had people who said they didn't hear any gunshots during that time frame that you said. And you told the jury everything was consistent. Why would you do that? In a case that was a death case, a person's life was at stake, and the Commonwealth of Virginia, who you represent, wouldn't tell it. Do you think, is it a doubt about that's Brady material?
The material
that you hid?
there's
Let's start with the Roberts.
Sure. As this court held in its previous opinion, that material is classic Brady material. That's only part of the question. The Brady material only goes to whether the evidence is exculpatory and favorable. There's a separate analysis about materiality, and that's the analysis before this court today. There are three elements to a Brady claim. There's the favorability of the evidence, there's the suppression of the evidence, and there's the materiality of the evidence.
I mean, it seems patently obvious that a theory of an alternate suspect is, by definition, almost always material, no?
It's certainly exculpatory, and I think that is what this court held in its previous opinion about the sort of being a classic Brady material. However, you have to look at materiality in the context of the overall case. And here we have a case where there is overwhelming evidence of his guilt. We have his thumbprint and DNA on the knife that was used to stab Keisha. We have DNA on a cigarette butt that was found on the shards of the broken door of Keisha's apartment. We have a 1244 911 call that pinpoints the time that the murders occurred, and fits with the prosecutor's timeline of events. And then we have Renee Rashid's testimony, which, regardless of any impeachment evidence that was put in by Mr. Juniper, consistently lays out both what happened in that morning that puts Mr. Juniper in the apartment, and also gives him a motive for committing murder, which is that he thinks that Keisha is not being...
Are we looking at the Brady standard here? It seems the district court at some point said, looking at it collectively, looked at NAPU and said it doesn't matter either way, so you applied that standard.
That's right, Your Honor. The district court held that regardless of the standard that you would use, whether you'd use the higher Brady materiality standard, the reasonable likelihood standard of NAPU, or the even sort of more deferential standard.
The thing is that, at least from your perspective, you are dealing with the NAPU standard here, which is a different standard than the Brady standard. Is that correct?
It is a different standard. I want to answer your question very precisely. We do believe the district court was correct in holding that regardless of the standard, because of the overwhelming evidence, that it really wouldn't matter what standard you would apply. However, we have the argument in our brief that is correct, that this court has looked to the reasonable likelihood standard, not the harmless beyond a doubt standard for NAPU claims, and would only look at the evidence that's relevant to that NAPU claim. Mr. Juniper argues that all of the evidence should be reviewed under that standard. That's not how this court has dealt with it. But the district court did look at it.
The court assumed the favorability aspect of it and the suppression aspect of it. Those are Judge Greger's indication of this is something you actually did, but it relied upon the materiality aspect of it.
That's correct. The only issue before this court is the materiality standard, both on the Brady claims and the NAPU claims. The favorability of the evidence, and then in Brady, the suppression, and in NAPU, the misleading nature of the testimony was all assumed. So the only issue before this court is the materiality. And again, we have...
Can I ask you to go back to the Roberts testimony and answer, if you can, the question I asked your colleague on the other side? So how are we supposed to assess that evidence 15 years later? Are we supposed to look at the statement as it was originally given to the police, which, if the defense had that, they could have gone to town on arguing that there was a different suspect. The timelines just didn't match up. So Roberts come into court, 10, 11 years later, and of course memories fade, and they're especially the mother is a little bit older, and it just makes for a much more difficult case. And the district court did what we told it to do, that is, gauge credibility. But I wonder if the court went too far. I mean, how do you gauge credibility in this context, whereas the chief indicates you all hid this evidence for 10, 15 years, and so why should you, on top of that, gain a bonus by now arguing, well, they aren't credible because 10 years down the road there's some inconsistencies in their story?
Your Honor, I think it's very important to look at what the district court held on the credibility point. The district court held that they were not credible. They were sincere, but not credible for two separate reasons. First was the difference in their statements over time, so the inconsistencies in their statement.
Is that proper?
I think that's absolutely proper, because your point that you made, Your Honor, in asking your question is that the witnesses are going to be asked, if there were to be a new trial here, they would be asked to testify, and their memories now are certainly relevant to what the evidence that a court would hear. But more importantly, it wasn't just the inconsistencies in the statement. It was their demeanor in testifying. The district court did exactly what this court asked when it sent back the case for evidentiary hearing. The district court brought the witnesses in, and Mr. Juniper had the opportunity to prove his case on materiality. The standard is now is no longer the standard that was being used in 2017 of assuming all of his facts as true. It was now his opportunity to marshal his case and put forward what the materiality of this evidence is. And he called only 9 witnesses, 2 of whom were the Roberts. The district court saw them in the courtroom, analyzed them as witnesses, and found not just because of their inconsistent statements, but also because of their demeanor in testifying, is what the court said, that they would not be credible, that no reasonable juror would believe these people. And so I think that that would be both in 2004 or in 2023 if there were to be a new trial. But regardless of because of the way that they presented themselves in viewing them, not on a cold record, but the district court seeing them in the actual courtroom, that no reasonable juror would believe them. And I do want to point out that—
How would that be? For example, Ms. Fraser, she lived under the apartment, right? Why is that not credible when she said, I heard some talking in the morning and moving furniture, but there were no gunshots that were heard until after between 1 and 1:30? Well, how do you look at it and say, well, no juror would believe you? Why? What it was about her that the jury couldn't believe her? What was it? Anything in the record?
Your Honor, a couple things that are relevant to the answer to your question here.
I'm talking about Ms. Fraser now.
I am going to talk about—
Okay, go ahead.
Mrs. Fraser was part of claim 4D in the petition that was before the court, and that claim had already been dismissed prior to this court hearing the case in 2017. And so the district court held correctly that that claim was barred by the mandate rule. So the Ms. Fraser evidence is really not before this court whatsoever.
And you benefited from that because you held that. So everything, it's memory loss or memory fading. So everything. So you take advantage of all of that. Isn't we trying to get to the truth of this thing here? And you hid the truth for a long time. And then you say, well, that's past and that's gone. And that's, for example, your chief witness couldn't say what time exactly it was when she left the house, right? And that was pretty current, wasn't it? So the jury believed that, I guess believed that testimony, but she couldn't say when she left.
The timeline of the prosecution put forward at trial was corroborated by witness testimony, which, as my friend on the other side pointed out, Ms. Rashid was not very specific about time. She, in fact, said on impeachment that she didn't really know what time it was. However, it was corroborated, her version of the events of the morning were corroborated by undisputed evidence, including that 12:44 phone call. And I do want to talk about that phone call because I think that call is very crucial.
Ms. Bowser said she made the call, right? She made the call?
Ms. Bowser, yes, that's correct.
She went to did she tell you what convenience store she went to?
I don't believe that's in the record, Your Honor, but regardless of where the call took place, Mr. Juniper would ask the jury to believe that that person was essentially a fortune teller, that at 12:44 they report shots
or involved in the case. And given a time marker that might not be maybe misleading and throwing off, it's a minute. How you say things in Commonwealth and then the court just believes that? Oh, that 12:45 definitely was. You don't have to be a magician. You could easily do that in a case, make a call. Matter of fact, the police got there and they couldn't find anything wrong at 12:44. When told she lives back there, didn't go back there. So how is this 12:44 the piece de resistance, as they say in French, yet the police officer who appeared didn't find anything? We don't know who made the call, and you say, oh, you have to be a fortune teller. No, you don't. You may have somebody who has some very direct knowledge and putting a false timeline on your theory that you took to the jury and made it unassailable, and witnesses were told each other what their statements were, and they really harked on it at trial. All of our witnesses were very consistent, right there, right down the line. It didn't tell any of the jurors anything about people, good, average, hardworking citizens who talk to the police. And that's what you're supposed to do. And then you suppress it and come here with these unclean hands, talk about a phone call that is unassailable, and a magician or a fortune teller had to give it. That's not true.
Your Honor,
Go ahead with your line. But you talk about that phone call at 12:44 had to be pure. I mean, I don't know what's the basis for that.
If the 12:44 phone call were the only evidence in this case, then maybe what Your Honor said would be what I would agree with. However, it is nowhere near the amount of information that the jury heard. The jury saw that Mr. Juniper's thumbprint and DNA were on the knife used to stab Keisha. They saw that his DNA was on a cigarette butt that was on the shards of the broken down door. So it places him in the apartment both that morning, based on Mr. Rashid's testimony, which is unimpeached by Mr. Juniper, and then also places him after the door.
How many of your witnesses were in the apartment?
According to the theory of...
No, not theory. According to your court, wait a minute, I'm asking a very, very specific question. Since you said appearance, how many of your witnesses were in the apartment that day?
Mr. Mings testified to having gone into the apartment, and then Mr. Jones was not a witness of the Commonwealth. But
no, you didn't call him, but he was there, right?
He was certainly at the premises. I think
he was there. That's two. Go ahead. Keep on. That's two. Go ahead.
And then Mr. Juniper was there as well.
We know that. That's the person. What about?
Oh, and Ms. Rashid was there earlier that day.
Right. So that's three. So yes. You say his presence alone made it clear that he had to be the only person who committed these murders.
It's certainly not just his presence, Your Honor. It is his thumbprint and DNA on the bloody knife that was used to stab Keisha, and it's also the cigarette butt on the shards of the broken down door. So it's not just the fact that he was in the apartment generally. I think this court had said in its earlier 2017 opinion that he was a frequent visitor of the apartment, and so his fingerprints, of course, would be throughout the apartment. That's certainly true, but we're not talking about fingerprints found on, somewhere in the bathroom, near the bathroom sink. We're talking about fingerprints and DNA on the knife used to stab Keisha, and then fingerprints on a cigarette butt that's on the broken down shards of the door.
Okay, what about the other victims were shot? So that means he shot them too? That's ironclad? And you have fingerprints on cartridges that didn't match him at all.
If I recall correctly, Your Honor, there were no fingerprints on the cartridges. There was one fingerprint that was found in the cartridge tray.
Oh, in the box.
In the box.
That somebody would put their hands in trying to get them out. Right?
That certainly could be how a fingerprint could come, or it could come in some other way. But
just like it could come a different way on a knife, but we're supposed to say it's the way you have it. But how do you get? I just don't understand. How do you get all these benefits here in terms of we're trying to search for justice, and you're the one. You and me, the Commonwealth, you deliberately hid this. And for example, Ming's testimony, how many different stories did he tell? Wouldn't the defense be able to say, yeah, you told us today, but you told this, another one, another one, another one, another one? Isn't that what jurors need to hear, that when you have that information before you?
And Your Honor, Mr. Mings was thoroughly impeached at trial. There were three main ways that the defense impeached Mr. Juniper or Mr. Mings' testimony, including on the inconsistencies of statements. When he initially talked to police, because again he made the 212 phone call, the second 911 call, his Bowser, his girlfriend, and they walked down to the apartment and met the police there when the police arrived at approximately 2:30. He talked to the police in that moment and did not mention Anthony Juniper. And so the defense counsel cross-examined him on that exact omission, the fact that he was giving inconsistent statements to the police when he was, from what he was now saying in testimony, which was implicating Mr. Juniper. So the evidence that they're pointing to of inconsistencies in his statement with police over the sort of intervening weeks as they were doing their investigation would have just been cumulative as to information that the jury had already heard. And again, we have to look at the big picture here, which is the evidence that the prosecution put on that shows overwhelming guilt toward that implicated Mr. Juniper. And so the prosecution or the impeachment of one particular witness would not have undermined the DNA and the thumbprint on the knife, the DNA on the cigarette butt that was on the shards of the broken door, the 1244 911 call that set the timeline of the murders, and then Ms. Rashid's testimony, which provided him both a motive and an opportunity. And I do want to make sure I talk about the evidentiary hearing and the standard of review that's before this court. This court sent the case back to the district court in 2017 to do exactly what the district court did, to allow Mr. Juniper the opportunity to marshal evidence about materiality and to bring forth the best part of his case by calling witnesses and having them testify before the court. The court then made certain credibility determinations that this court has held deserve the greatest amount of appellate deference, and made certain factual findings that should be reviewed only.
We held that in the context of a Brady hearing. I mean, the cases that were cited were different contexts, ineffective assistance of counsel and a Schloop hearing, but I didn't see anything about the deference owed in a Brady context, which gets back to my concern about this. Are we supposed to look to the witness as he or she would have testified back then or now?
I have two responses to that, Your Honor. First of all, the general proposition that is laid out of credibility determinations receive the highest level of appellate deference, that certainly would apply regardless of the context. I do agree with you that the cases that we cite are in a slightly different procedural posture, but the general principle is something that I think we could all agree on. And then number two, we want to make the point that the credibility determination that the district court made is certainly helpful, but it's not determinative. While this court might have some unease about the credibility determinations that the district court made, the district court did exactly the correct analysis, which was looking at each piece of evidence that Mr. Juniper has brought forward, analyzing them item by item to see the tendency and force of it, and then analyzing the cumulative materiality of it at the end of the opinion. And the district court looked at this case, as this court has directed district courts to do, by looking at the prosecution's case as a whole, and then how the new evidence would have changed the way that the jury would have looked at that case. Is there a chance that the jury would have, or is there a reasonable probability that the jury would have reached a different verdict? And again, because of the overwhelming evidence against Mr. Juniper, the district court correctly concluded that there's no reasonable probability. And as Judge Wynn pointed out, went even further and used the incredibly deferential standard from the Elmore, is a parenthetical in the Elmore case that Mr. Juniper points out to, and said it would be harmless beyond a reasonable doubt. And that decision was 100% correct, given, again, the overwhelming evidence against Mr. Juniper. Regardless of what Mr. Juniper points to of this new evidence, there is nothing that undermines the thumbprint and the DNA on the knife, the DNA on the cigarette butt that's on the shards of the broken down door, the 1244 call that would have to have correctly predicted the exact crime at the exact location that Mr. Juniper argues happens an hour later, and then also Ms. Rashid's testimony, which places him at the scene of the crime and gives him a motive for doing so. And just my last point that I want to make, as I see my time is about to expire, is that the evidentiary hearing was, this case was sent back for the Roberts testimony. It was sent back for the district court to listen to Wendy and Jason Roberts and to determine whether they were credible and whether Mr. Juniper had shown materiality. And the Roberts testimony, as Judge Diaz, you pointed out, was all over the place. They were inconsistent from 2004 to 2011 to 2021 when they spoke at the evidentiary hearing on whether they saw a different person, whether they saw Keisha at all, whether the son was involved, and then the build and size of the person that they saw, if they saw somebody. And those inconsistencies, again, when this was the crown jewel of their case as to why he should be granted habeas corpus, the evidence just really hasn't borne out. So unless the court has any further questions, we would ask the court to affirm the district court.
Thank you.
Thank you.
Gallagher. Ms. Zogby?
I would just start by saying, I think, asserting that this didn't matter is really rewriting the record, because what the prosecution argued in closing is the best evidence of what was material. And in closing, the prosecutors assured the jurors that their witnesses' stories aligned purely because they were telling the truth, and that they told the jurors if there was anything in prior statements to suggest that there was witness coordination, the defense counsel, as good as they were, they would have brought it to your attention. And they knew that the defense counsel couldn't bring it to the jurors' attention because it was being concealed. I think you mentioned how many stories Tyrone Mings told. There were at least 8 concealed statements, prior statements from Tyrone Mings and his girlfriend, Melinda Bowser, that did not match their testimony at trial. There is evidence that there were over a dozen total prior inconsistent statements from their witnesses that were concealed, some of which had been marked with an E or marked with the word exculpatory in the margin and then were not turned over. They knew that they were hiding this evidence, and they still argued to jurors that it was important that their witnesses lined up so well, and they were
told the jurors that if anything existed out there in the cosmos that showed it was not, then they would have presented it.
Yeah, they said.
Knowing they had all of this themselves.
Yes, they said the defense counsel's really thorough, they would have brought it to your attention. The defense counsel couldn't bring it to the jurors' attention because they didn't have it, because it was being.
Going to, I guess, the government's files and find them.
They didn't have, yes, they didn't have access to the government's files, and we didn't even obtain this until 2018 on remand from this court. And we talk about we were remanded to hear from the Roberts. That's because we didn't know that anything else existed at that time because it still was being concealed. 15 years after the fact, they were concealing evidence that police, in fact, had coordinated witness testimony. We have stipulations that police were showing witnesses other witnesses' statements. They were showing them photos of the crime scene. Exactly what they promised the jurors didn't exist, did exist. And so to now say, oh, that didn't matter, why was it emphasized to the jury? It was one of the last things the juries heard. Why did they go to these lengths to hide this stuff, to deceive the jury?
So can I ask, I think, and of course I can't speak for the jurors because I wasn't there, but in reading through this record, personally, I thought the most compelling witness in this case is Ms. Rashid. So I need you to spend some time, if you will, telling me why the evidence that was not presented to you was deliberately withheld, somehow impacted her testimony, because as your friend on the other side mentioned, I mean, she was there at the very beginning of that day, heard the arguments between, allegedly, that she testified, between Juniper and the victim in this case, left the apartment, heard the bang of the door as it was being broken down, again, according to the prosecution's theory of the case, heard 4 shots as she was leaving the car, saw the infant in the bathtub with a magic marker on her, and it turned out that was correct. I mean, you can attack all these other witnesses, but Ms. Rashid, it seems to me, is a pretty compelling witness. So tell me what you could have done with her had you had this information that was not presented to you.
So Ms. Rashid was impeached somewhat to start with at trial. Ms. Rashid has admitted she had a serious crack cocaine addiction at the time of trial. Her
that
timing.
Was presented? That was presented?
They didn't say that, but it may have been evident. I don't know, I wasn't there, but.
Well, I just want to be clear, the prosecution didn't hide that, right?
Not that I'm aware.
Okay.
And the timing was of her story was a little bit implausible to start with. I mean, the idea that she's hearing them arguing, and then as she's driving away, suddenly there's shots. Somehow in between there, Juniper is supposed to have stabbed Keisha. She didn't hear a scream, none of that. So that was all presented at trial. But what wasn't presented was, first of all, again, that timing evidence, Francis Frazier, and this, and the warden has argued we can't consider Francis Frazier. That's not what the district court found. The district court found that even if the mandate rule does apply, which we would argue it does not, but even if because there was new evidence and discovery related to Francis Frazier that allows this court to open up that claim, but even if it wasn't considered, the district court found that her statements were properly considered in cumulative materiality, because it's about how the defendant's case would have changed had the Roberts evidence been turned over. And again, when we think about the Roberts credibility, it would have been backed up by these other witnesses too. But returning to Rashid, she's impeached by Francis Frazier, the downstairs neighbor who didn't hear anything, and that's evidence that we did not have. She's impeached by the many people who saw people coming and going to that apartment during the time when, according to her, the witnesses, there would have been 4 dead bodies in there. She's impeached by Wendy Roberts' statement that she saw someone go into that apartment, come out, and then was arguing with Keisha, again, during that time period where Keisha was supposed to have been dead. She's also impeached. She omitted Murray altogether from her initial statement. She didn't describe him at all. And she says at trial, I just spoke too soon. The concealed evidence shows that she's not the only witness who omitted Murray. Every single witness in this case did not mention Murray in their first statement.
Where we are in this case is not where we were maybe a few years ago when you had a death penalty you were dealing with here. And then, of course, Virginia didn't commuted his sentence to life without parole. It's a different situation today. And the evidence we're being presented here now is, okay, you have Brady, perhaps NAPU violations here. The ultimate issue comes to, even if the defense knew about this, what is the result? What indicates this result would be any different? And we can argue all day about what actually was done, but it's more probably in terms of materiality, we need to look at what was the evidence that was there. And to follow up on Judge Diaz's question, there seems to be nothing to undermine the forensic evidence here or Rashid's testimony. very powerful evidence that's in this case. And while your points are well taken, these things happen. They violated the Brady on this. But the ultimate question, which the district court focused on, was materiality. And that standard is, under these particular rules, makes it somewhat very difficult to show that even if you knew this, a reasonable juror is going to come out differently based upon, it may seem to be in the eyes of some relatively minor evidence that the violations, it may not, compared to what was actually presented, forensic evidence. And maybe speak to that, maybe because maybe I'm not viewing this forensic evidence correctly, or at least Rashid's testimony. But how do you view this forensic evidence? Wasn't it relatively powerful evidence in this case?
I see my time has expired.
You may
Just briefly,
respond.
I'm just trying to assess, because we have this evidence. Okay, if we take there were violations, which the district court did, says, okay, it's favorable to you, it should be suppressed, the whole bit. Even with that, that forensic evidence is pretty damning, is it not?
Brady is not a sufficiency of the evidence test. And so the question is not, is there enough evidence?
Even in this instance, I pointed out, the district court used the NAPU standard here when they looked at it collectively on it. So I'm not going to the sufficiency of it. I want to, what is it about this that shows that it undermines the forensic evidence in the Rashid testimony such that had the defense been aware of this evidence, the result of this proceeding would have been different?
So first, to the forensic evidence, that evidence points both ways. There was a fingerprint on a cartridge tray, which is, again, the murder weapon was a gun, that did not match Mr. Juniper. That was someone else's fingerprint on that cartridge tray, and we don't know whose it was. And that, when a jury's weighing fingerprint on the knife and a fingerprint on the cartridge tray, that's something a jury, should have been able to decide. And of course, in this case, they went with the knife because of all of these witnesses. If the knife alone were enough, it sort of begs the question, why present all these witnesses? Keon Murray, for example, got on the stand and took the fifth. He tried not to testify, and the prosecution went to great lengths. They granted him immunity to get him to testify. It shows that they clearly thought that they needed these witnesses. And also, you have this cigarette butt that's on top of the door shard they make much hay out of, but it's been stipulated that there was no evidence that cigarette butt was on there when the police first entered. A reasonable juror certainly could have believed that it was kicked up onto there. And we also have the cigarette butts and cigar butts that were found in the ashtray that was found in the room with the victims on the bed. Renee Rashid has said that she saw an ashtray that morning, it was empty. And the only ashtray that the police recovered from that apartment was the one that was in the bed that was full. And the DNA on those cigarette and cigar butts was not consistent with Juniper. It was consistent with Keisha Stevens and with two other individuals, which indicates, again, that there were people alive in that apartment, and that Keisha was alive in that apartment after Renee Rashid left. So when you talk about the forensic evidence, there is some forensic evidence, certainly, that the prosecution could use to argue that Mr. Juniper committed this crime, but there's also evidence that the defense could use to argue that he didn't, that it was someone else. And as to Rashid's testimony, I would also just mention Rashid was interrogated both times by Ford and Detective Ford and Investigator Ray. And it's been stipulated in this case that Ford threatened another witness, that he showed a witness photos of the crime scene, that Ray was telling witnesses what other witnesses said and showing them evidence. And so when you talk about something like the marker on the face of the child, it's entirely possible that a reasonable juror would think that might not have come from Rashid herself, that might have been evidence that was given to her by the police. When you have misconduct at this level, police telling witnesses what other witnesses have said, the prosecutors deceiving the jury about it, the prosecutors, the district court found that we met the first two prongs of NAPU as to Keon Murray. They intentionally presented false testimony. A jury would reasonably doubt Rashid's testimony. And again, I would just point to the timeline evidence regarding Rashid's testimony. There are witnesses who had no skin in this game, who were not granted immunity, who were just neighbors, who said that they had seen Keisha alive after Rashid said she should have been dead. There were witnesses who saw people going into that building and coming out, after they were all supposed to have been dead. And so the jury should have been allowed to make the decision about what timeline to believe, about which witnesses to believe, and they weren't able to do that. And the question under Brady is, can we have confidence in the verdicts that jurors came to? And when there was this much evidence, a mountain of evidence that was intentionally concealed and that jurors were intentionally deceived about, in closing arguments, some of the last things that they heard, that does undermine confidence in the verdict that they reached. And you know, certainly there were arguments that Rashid was credible that could have been made, but there were plenty of arguments about impeachment, and all the jury heard was one side because everything else was concealed. This wasn't a fair fight. It wasn't a fair trial, and we cannot have confidence in the verdicts that jurors reached as a result. This court doesn't have any more questions. That's all.
All right, thank you, counsel. With that, we thank you for your arguments, and we'll come down and greet counsel. Ms. Hashimoto?
Thank you, Your Honor, and may it please the court. Erica Hashimoto from the Georgetown Law Center on behalf of Mr. Kurika. With the court's permission, Ashley Stewart, a third-year law student, will present the argument on behalf of Mr. Kurika.
Thank you. Ms. Stewart?
Good morning. May it please the court. Mr. Kurika entered his guilty plea without knowing that he faced 90 years in prison. This happened because no one affirmatively told Mr. Kurika the relationship between the sentencing guidelines and the statutory maximum. The post-conviction relief court found that the sentencing judge made it clear to Mr. Kurika that the guidelines are advisory only. That finding is unsupported by the record. Had Mr. Kurika known that he was facing 90 years rather than 30 to 51 years, he would not have pleaded guilty. The PCR court's decision and finding...
What he will face if he doesn't have a plea agreement?
Mr. Kurika does have a plea agreement.
But if we set it aside, what will be the most he will face?
Mr. Kurika would be facing the statutory maximum of 90 years, but it needed to be made clear to Mr. Kurika that the guidelines had no impact because the plea letters that he received from his counsel and the state both mentioned the sentencing guidelines, and they were mentioned at the plea colloquy.
I just want to be clear on the point. If without a plea agreement, he walks into court, he's convicted, what the most he would face from your perspective would be 90 years?
Didn't the state dismiss some charges against him, and wouldn't those be reinstated if he didn't have a plea agreement?
Yes,
So it'd be more than 90 years,
it
right?
could be more than 90 years if it's the same, if they did not decide to lower the charges.
Yeah, it seems without, just not to belabor, but that without that plea agreement, he's going to face first-degree murder. That would be life without parole. So if we set aside this agreement, he could be convicted and then face life without parole. Correct?
Not necessarily. If the state allows him to replead,
Well, I understand the conditional aspect of it, that the state could allow him to do it. But this evidence, well, maybe when I see a case like this, I'm thinking, well, this must be a particularly hard case to prove. In other words, there must be something that gives the state great incentive to want to do a plea agreement on this case. I don't know if this case fits in that category, at least in terms of the evidence that seems to be there. I don't know the full case, but if it is a case that the state could prove, why wouldn't it just say, okay, we'll set it aside, we'll try this case and argue for life without parole, which he certainly could get. Not certainly, but it's a possibility, I should say, he could get. Don't you agree? Just examining in terms of what you're asking for. Sometimes you can ask for a remedy or something, and it may not, the ultimate result may be worse than what you had before you asked for the remedy. And I certainly hope that doesn't happen here, but the possibility does exist. I wanted to at least to start with that as a framework before we proceed. You do agree with that?
yes, that possibility does exist.
He fully understands that.
Yes. And I think out of efficiency, everyone wanted to enter the plea agreement. But the issue here is that Ms. Rika had no idea what that plea agreement actually meant.
Well, he did know some things, right? He knew, because the court, the PCR court found that he knew that he wasn't promised a guideline sentence. Do you agree with that?
The PCR court found that the sentencing judge made it clear to Mr. Krika that the guidelines are advisory only and that he knew what he was pleading guilty to. And we find that is unsupported by the record.
Well, I didn't ask that. I asked whether or not the PCR court made a finding that your client wasn't promised a guideline sentence. Is that right?
Yes.
Okay.
But under the Boykin and Brady analysis, that does not affirmatively show.
I understand, but let me just, so here's what else I think the PCR court found, and you tell me if you disagree, that the plea court ensured that Karika understood his maximum sentence exposure, that is 90 years. Do you agree with that?
That is what the PCR court found, that
Right.
he understood the maximum penalties.
And then the last thing he found was that he made a subjective finding of credibility with respect to your client, that he simply didn't believe him when he said he thought that he would be that he would be sentenced according to the guidelines. That's entitled to some deference, right?
That stems from its factual finding that the sentencing court made it clear to Ms. Triga that the guidelines are advisory only.
So you
That is-
disagree with that? You don't think that's correct?
It's unsupported by the record. Yes, I disagree.
All right.
And the standard is an objective one. It's whether the record affirmatively shows that Mr. Rika was told his maximum sentencing exposure. And so,
I mean, as you read this transcript, it's not a model of clarity, I'll grant you that, but with respect to the three charges that Mr. Karika pled guilty to, I mean, if you read the transcript as a whole, it seems fairly clear that the judge told him, it's up to me to decide what the sentence is in the context of the maximum sentence for each of these charges. I mean, that's how I read this transcript, and isn't that enough?
it should be based on what a reasonable person in Mr. Karika's position.
I'm sorry to interrupt you, but particularly in the context of an EDPA claim, where we have to be, I mean, no fair-minded jurist could come to a conclusion as to the reasonableness of the PCR court's finding. Given that standard in particular, it seems like a pretty difficult road to hoe here.
The PCR court found that the sentencing judge made it clear to Ms. Trika that the guidelines are advisory only, and that is the only finding that supports its conclusion. And the credibility determination does not support its conclusion either, because everything in the record, not just the plea colloquy transcript, but the letters, the plea agreement, and the plea memorandum were too confusing for someone in Ms. Trika's position to understand his sentence.
Ms. Stewart, you agree you're not making an ineffective assistance counsel claim here today, right?
Correct.
All right, so let's just agree on the facts. the facts start with a contract, correct? That's what.
The plea agreement, yes.
Case law clearly says we treat these agreements as contracts. You agree that in this contract, it did not say what his sentence would be?
Correct.
Okay. And he pled guilty, and they did their part. They dropped the other, whatever, a bunch of counts, and then he pled to the 3. Do you agree that he was told that the maximum sentence for each was 30 years? 30 for one, 30 for the second, 30 for the third. You agree with that?
Yes, that was in the transcript. But what was also there was the sentencing guidelines.
Let me
range.
add to that yet. Okay, but let's agree on what we can agree on. So we agree with that. So now let's get to the guidelines. The guidelines were there, and I agree with you. The government gave the wrong guidelines to his counsel.
It appears so.
Yeah, gave the wrong guidelines. And then, but those were guidelines. What now, tell me then, what is it that was breached by the government in that scenario when he got 85 years?
The breach is ultimately up to the court it's their obligation to make it clear what Ms. Trika's sentence is. But if there was any place in the record that said the guidelines are advisory, it's just to a layperson, guidelines don't necessarily tell you that they are advisory or that they don't impact your sentence.
Well, he had a lawyer.
And there's no place in the record that the lawyer told him the relationship between the guidelines and the statutory maximum.
Why wouldn't we just take the word guidelines to mean just what it says, guideline? It's a guide.
Historically, guidelines,
It's not required, at least under Maryland law, it's advisory. So why would not be the case? But to allude to maybe where Judge Gregory started out, says this is not an ineffective assistance of counsel. To what extent does a defense counsel have an obligation to explain that this is not mandatory or this is just advisory? I mean, if it comes in and you have this contractual relations represented by counsel, I mean, does the counsel just hear this and don't whisper to the client, and these are just guidelines and they're not advisable, or they just let it go? And if we do that, why would we ever say he has to advise anything? The best thing for a defense counsel to be don't explain a thing in the world that you hear in that courtroom, because if you do, then you would be knowing of something. But if I tell you, then you would know. You would know. So, or why wouldn't we, let's say, if we're going to say, I think we ought to look at counsels, except that they're going to be competent, unless there's something there. Why wouldn't we think a competent counsel explained this to him?
I completely agree that a competent counsel should explain the difference between statutory maximum and sentencing guidelines range. And Boykin and Brady specifically emphasized the court's obligation in explaining that as well on the record. And so the issue here is no one affirmatively told Mr. Krika, and I think his actions following his sentencing demonstrate that as well. As soon as the state mentioned a higher guidelines range at sentencing, his defense counsel did say, this is not what the parties agreed to. And Mr. Krika walked into his plea colloquy thinking that the parties had agreed to 30 to 51 years, and so that must be his sentence. And it was never made clear otherwise that he could receive 90 years. And brief references to the statutory maximum are simply not enough, and there are several cases that explain that when there are two sentencing ranges or numbers on the record, and it's never explicitly explained what sentence applies or what impact those sentences have. And it was objectively unreasonable to return to Judge Diaz's question about epidefference and how to go over that standard. The PCR court's decision is ultimately unsupported by the record, and it unreasonably applied Boykin by discounting some of the record evidence. The 5 mentions of the sentencing guidelines at each turn when the statutory maximum was mentioned made it confusing and muddled for Mr. Kurika to understand his sentence. And Boykin requires that the court, and I'll quote this because this is important, the utmost solicitude, particularly in cases when the stakes are this high. Mr. Kurika is serving an 85-year sentence currently, and he entered his plea agreement thinking that he would receive 30 to 51 years. And there is no reasonable assurance from the record that he was told 90 rather than 51 years, and that is what we are looking for. The reasonable assurance, some affirmative information in the record that shows an explanation to Mr. Kurika, a layperson, that the guidelines had no impact on his sentence.
Boykin was an extreme case where the judge said nothing to the defendant about his plea. And I understand that, something more is needed than that, but is it fair to say that a defendant needs to understand each and every factor that goes into a sentence when deciding whether or not a plea was voluntary? Because, as I said earlier, this is not, I'll spot you that this is not a model of clarity when it comes to the advisory sentencing guidelines, but we have a lot more here than we had in Boykin, right?
Yes, and I think the cases that apply Boykin afterwards, for example, there is a case in the Second Circuit, Hansen v. Phillips, which is very similar to this case, in which the court recognizes Boykin's principle and says that we're looking for something affirmative in the record that explains the sentence.
Was that a habeas case or?
Yes. And there are several other cases, including Jameson v. Klim in the Third Circuit, that it's clear that the Boykin's principle has been discussed several times since then, even if there's a plea colloquy transcript that this court can review, unlike Boykin.
So back, I asked you this earlier, and I think Judge Gregory was getting at this too. When the judge told the defendant, here's the maximum sentence for each of these counts, and I can sentence you to whatever sentence I want, it's entirely up to me. Wouldn't a reasonable defendant at that point have an understanding that, wait a minute, it's not, there's a disconnect here. Even if he thought subjectively he was going to be sentenced according to the advisory guidelines, once he hears that from the judge, at that point, isn't he now been correctly informed?
No. He said, I can impose whatever sentence depending on what I determine. And that could tell
about limited by the guidelines. It just seems to be an unconditional exercise of discretion subject to the maximum sentence for each count.
It's not clear that that discretion is within the 30 to 51 year range or 30 to 90 or above 90 at that point, because whatever sentence does not tell Mr. Kurika what his actual sentence is. And that's why I think the cases focus on this affirmative language, because saying that I have no obligation is not necessarily an affirmative statement saying that you can receive 90 years in prison. Do you understand that?
He didn't say that, I'll grant you that, but close enough for government work, I guess, is what your colleague over here is going to say.
And unfortunately, the record at several times mentions the sentencing guidelines, and so that was never enough for Mr. Kurika to understand. Specifically, someone saying whatever sentence, and depending on what I can determine, he already went in there thinking that he could receive 30 to 51 years, and so something affirmative and direct and consistent and accurate needed to be said to make it clear to Mr. Kurika what he was actually facing. And we ask that this court reverse and remand with instructions to grant Mr. Kurika habeas relief. If there are no further questions, I will reserve the remainder of my time for rebuttal.
Thank you, Ms. Stewart.
Good morning. May it please the court. Andrew D. Maselli, Assistant Attorney General, on behalf of Respondent Appellee Warden Richard Miller. Judge Diaz, I would not say that it's good enough for government work, but perhaps good enough to satisfy the AEDPA standard. Maryland's sentencing guidelines are never binding on the state courts. Mr. Kurika's written plea agreement said nothing about guidelines. Mr. Kurika was never told that his sentence would be capped by the guidelines. And the plea court properly advised Mr. Kurika that he could be sentenced up to 30 years on each count. Thus, Mr. Carica was sufficiently advised of the nature and consequences of his plea, and the post-conviction court's decision was not objectively unreasonable.
Well, the guidelines were part of the negotiations for the plea, were they not?
They were, I would not characterize them as part of the negotiations. The parties certainly discussed them. They appear in the plea offer letter.
Yeah,
They appear in the discussions, but they weren't part of the negotiations of the plea agreement because, of course, they don't appear at all in the plea agreement. The only thing that appears in the plea agreement regarding the sentencing is that the state reserves the full right to allocute.
Well, what are they then? Are they just surplusage? What's the purpose of the guidelines? And matter of fact, the government took the time to calculate them, although we found out they were wrong. And you put those in, they were in the papers. What was the purpose then for the guidelines?
I think the guidelines are important for two reasons. One, to advise the court, to give the court a general baseline, but also it's a predictive tool. It provides the defendant sort of a baseline understanding of what the guidelines would recommend to the court so that he can assess the quality of his plea agreement.
Right. You said the key word. It is a predictive tool. And it factors in whether or not you want to roll the dice and plead guilty, doesn't it?
Well, he did not accept a plea agreement that had a binding sentence. That's the critical aspect here. That
So then we don't have to worry about that. That's not before us. The one that is before us, he did accept. And my question then is to you is, isn't that a part of the calculus you make in the risk? For example, all right, the district court says, I can give you up to 90 years. But then you have these guidelines. And as you said, I can say it better than the predictive aspect of that is, well, okay, he could give 90, but the guidelines, and lawyers know this, that's like the average range and medium range. It's all done, the commission and all those things, you know how that's put together. It's not assured, but it goes into the thing. So then isn't that sort of like a carrot on the stick, and then all of a sudden you say, wait a minute, oh, that changed.
I don't think it's necessarily a carrot. Again, I mean, the question before the court, I think, is whether Mr. Carica was properly advised of the nature and consequences of his plea. And he was never guaranteed a particular sentence within the guidelines range. And it's no different from...
But was he lured into it, though, by your incorrect calculation of the predictive tool that assesses risk?
I don't think that he was necessarily lured into it at all.
Well, necessarily. That is luring someone. You said guidelines are a lot lower. They're lower. The things, the judge could give you this, but the things that the judge will look at in terms of what the average people get is lower. Then all of a sudden, at the sentencing hearing, he said, oh, it's higher than that.
Well, I mean, it's...
21 years higher, right, on the high end.
That's true, but Mr. Carica was always able to negotiate a plea agreement that had a guaranteed sentence within the guidelines, but that's not what he negotiated for. He negotiated for a plea that allowed him to escape life imprisonment for first-degree murder. And that certainly is probably the most important calculus in Mr. Carica's decision. We don't know exactly what he discussed with his attorney, but the plea agreement...
Well, we know that's not true now because... As Judge Wynn aptly asked the question of counsel, Ms. Stewart said, we understand that, and this is our position. So it's not correct that he would do anything to avoid that harsh sentence because he's here today. And that's exactly what happened. If they win, it goes back, the government likely would, whatever, but he would face it again. So we know that's not true because that's been borne out today. He's here with that risk, but he was told that the guidelines were lower than, oh no, they're higher, they're 21. And then that kind of thing. I mean, I don't really understand how, I guess I'm a dinosaur. I used to practice criminal defense work, and it was totally different, but you go in there and you plead guilty, and then you get 85 years. I mean, that's interesting, but I guess, and then you said you were going to allocute, right? You reserved that right to allocute?
That's what the plea agreement said, that the state reserves the full right to allocute, which
What does that mean?
Well, Mr. Carica understood it to mean that they have the right to advocate, which I think is...
Advocate for what?
For the sentence that the state believes is appropriate. And that's precisely what the plea agreement contemplated.
Did you tell his lawyer you're going to go in there and ask for maximum 90 years?
I don't think that the record demonstrates exactly what Mr. Curica's.
Well, don't you think that would be fair? I mean, in other words, you're in a contract, you said, look, there are guidelines, there's a maximum, but I can tell you right now, when you plead guilty and we go there, we're going to ask for the max. Wouldn't that be fair?
Well, I point the court to the plea colloquy at the hearing. That's what Boykin requires, that there is something on the record to indicate that the defendant understood the nature and consequences of his plea. And in this case, the court, who had a discussion with Mr. Curica, said that you are liable for a maximum penalty of 30 years in jail, depending on what I determine, and you can be placed on probation for any suspended sentence that I might impose. I'm entitled to impose a sentence that would include a component part or part of it that would be suspended. I'm not obligated to do that. So each of these charges carries the possibility of being put in jail for up to 30 years. Once again, I can impose whatever sentence, including jail time, and a period of suspended jail time if I wish to do so. So that colloquy sufficiently advises Mr. Curica that he is liable for up to 90 years. He is now on notice that his plea agreement does not bind the court to any particular sentence.
Yeah, that's what maybe, not on the soapbox, but I just don't understand that. In the United States, we have the most protective system in terms of people charged with crimes in the world. And we consider that to be a trademark of our Constitution. And the right to have counsel, the right to have a jury trial, the right to go and call witnesses, and all those things are very important. So when you're talking about plea agreements, that's really, I mean, the framers would say that's one of those things where you're going to go offline and eschew all of those rights that you have for this. But don't you think you want to make sure that it's no ambiguity as to what it would be, what you're giving up? It's almost like, see, to me, you ought to tell them at the Rule 11 quality, listen, you giving up all these rights, let me tell you, I can give you the maximum sentence. I don't care what your lawyer told you. I don't care what the guidelines say. You would be really silly to give them all up because that's what I can do to you. Wouldn't that be a fair way to, then you could say, on the record, right? Then we told them. Instead, you get things like, well, we gave them guidelines, and then we switched the guidelines right at the end, and then we did that, and then we asked for the maximum when we got there. I mean, is that the way we really think the framers meant that? You're giving up some precious thing. Tell them the truth. Yes, I may give you, and very likely will, 90 years. So you really want to give up all those rights? We don't do that because we wouldn't get that many pleas. Would we?
There's a lot to unpack there.
Oh, come on, counsel, tell the truth. we wouldn't get many, would we?
I think that Mr. Curica was sufficiently advised.
You're not going to answer my question.
No, I think that as Judge Diaz put it, this record is not ideal. It's not a model of clarity.
Right.
Certainly, I would wish that there was more time spent on this discussion. But the question, I think, before the court is not only whether Mr. Curica was sufficiently advised, but whether any reasonable court, whether any court could find beyond a possibility of fair-minded disagreement that he was sufficiently advised under the AEDPA standard. And certainly Boykin and Brady require there has to be a record that Mr. Curica, that the defendant understood the nature and consequences of his plea. But I don't think that the state post-conviction court's ruling was contrary to that precedent, nor was it an unreasonable application, as the district court found below. Again, certainly we would prefer that there was, more discussion on the record. But again, the post-conviction court explicitly told Mr. Curica, I can impose whatever sentence up to 90 years, 30 years on each offense. That's what the court told Mr. Curica. And at that point, that was the opportunity for Mr. Curica to say, well, wait a minute, that's not what I expected. Wait a minute, that's not what counsel told me. Wait a minute, that's not, what I want to do. But at the time.
So here's what this case is, it kind of challenges you as to why we're going in this direction. But it seems as a matter, if you were looking at in terms of factual it's not just a pie-in-the-sky argument that he didn't understand it. It seems to have been his counsel's belief that that's what it was. When he shows up with the pre-sentencing report and finds out it's 45 to 70 years, he then turns to the judge and says, Judge, you know, I understand it's 30 to 51. We'd ask you to honor our understanding in sentencing him. That looks to me like that counsel also thought that this was within the guiding range of 30 to 51. And we're only talking about the difference in the 30 to 51 to the 45-70, not the 30, 30, 30 to 90. There's some confusion here that's going on, and you know, every court, you know, when we sit in these appellate courts, we sometimes forget how different courts run. Some run more locally oriented with understanding. Others are a little bit more formal. We typically find those up in near the, you know, when you get into the bigger city type areas there. But sometimes there's a little country lawyering going on and understanding with the DA, because you know you're going to be dealing with them a lot. You're going to deal with the judges. So you got this plea agreement. First of all, you got it from first to second degree. I think that's a pretty good hit right there. Judge thought so. That's a big deal. The judge thought it could have been first degree, but it's at second. So that in and of itself has reduced the sentence to some extent from life without possibility of parole. But when you look at this case holistically, there's a troubling thought. What was the counsel thinking on this case? Because it really does appear as though this defendant here, all he's hearing, I mean, why even tell him if it can be 31 to 50, 51 years or 45 to 70 years if he can be sentenced up to 90 years? Why not just say 90 years and then I got to feel something I could if I want to follow, but I don't have to. You say that's what he said, but it's not that explicit. And I think what muddles it is when the counsel has represented here, Judge, he's arguing about this other guidance range. He's not arguing about the 90. He says, you know, that's not our understanding, is to go up to 40 to 70. Our understanding is, you know, the lower lane, 30 to 51. Why is that not important?
I think the critical factor there is that surely it's unfortunate that the parties miscalculated the guidelines, but despite the fact that defense counsel at the sentencing hearing argued that the court should honor the original calculation of 30 to 51.
Let me ask you this. Could a plea agreement be made for the miscalculated length? In other words, could they have had could the DA make a plea agreement with the defendant of 30 to 51 years? Even if it can be calculated, the guidelines be like, could that have been?
Absolutely. I mean,
So that's the
it's
problem.
our position
it's
that
not a question of you know, did you miscalculate it? The miscalculation doesn't matter if that's what you brought to the plea agreement and that's what you agreed to. Then if you later on, then, I mean, it's sort of like anything else. The government made a mistake. They should have looked at a different range.
Well, that's I think Your Honor's critical language is brought to the plea agreement. It was never incorporated in the agreement. That's the critical problem here, is that Mr. Kurilka is expecting a sentence within the guidelines, even though at no point was he ever promised a sentence in the guidelines. And he, in fact, raised his primary argument below was a Santabello claim, a breach of contract claim, which the courts readily rejected because there was no language in the plea agreement. There was no agreement at all whatsoever, which is why if the court were to vacate the plea agreement.
You know, go more to what Judge Gregory is going on, but really, probably as you begin to deal with these plea agreements, you probably ought to focus on, from the defendant's perspective, probably the most important term in that agreement is how long am I going to be in prison? I mean, all the other stuff you put in there, whether it's first or second, is a big deal, but why wouldn't you be more explicit on that? It seems to me, even a trial judge is going to say, okay, this is the sentence you are subject to. We're not worried about a plea agreement or whatever, but this is what you can be sentenced up that amount. That seems to be missing to some degree, but you say it's here implicitly because of the way, and I will admit the trial judge did go quite a way to even bring up the 30-30 and say, you know, you can be sentenced anywhere along those lines.
I mean, again, I think that this record is not ideal, and that I would be much happier to argue on a different record, but the plea court's advisements sufficiently indicated to a reasonable person in Mr. Carica's shoes that he was liable for 30 years on each sentence. And that is sufficient to indicate to him the nature and consequences of his plea. And the fact that the court never told Mr. Carica that he could be sentenced and he would be sentenced within the guidelines was sufficient. And I think on top of that, in addition to sort of the objective record, that's part of the reason why we argue that the post-conviction court did not believe Mr. Carica. Mr. Carica's testimony.
To try this case, is there enough evidence to convict this defendant right now, in your opinion? If you set aside the plea and say go back to trial on it, could you just try the case and convict him?
I couldn't say for sure exactly all of the evidence they have, but I understand that there was a partial confession and DNA evidence.
Co-defendants.
And co-defendants as well. I don't know if they would testify against them or not. Of course, we haven't had a full trial on this issue, so I don't know what all the evidence the state would have. But certainly, I mean, of course, but that's the parties agree to, to a plea agreement in order to avoid sort of the uncertainties of trial and the uncertainties of, or the certainty of, potential certainty of receiving a life sentence. I mean, I think that is a critical factor. But
as we set it aside and everything's back on the table, you can go for first degree, you can go for all of that. Is that right?
I think that's correct. Yes, I think that's correct. And but to sort of back up, I think in addition to the objective record that we have, the post-conviction court explicitly rejected Mr. Carica's testimony. He testified that he believed that he was going to get a sentence within the guidelines range, and that he did not understand that his potential exposure was 90 years. And the post-conviction court flatly rejected that and said that he knew precisely what he was going to plead guilty.
How do we deal with that credibility finding?
I think that is dispositive of his claims under AEDPA, that it fundamentally undermines his claim, which is that I misunderstood, that my plea was not voluntary because I did not understand that I could get 90 years.
Does the defendant challenge it in the opening brief?
I'm sorry?
Does the defendant challenge that finding of the PCR court in opening brief?
Does the PCR court challenge that?
Does the defendant challenge?
I don't think, I raised it in our responding brief, that particular defense. So they would not necessarily have the opportunity to raise that in their opening brief. But, ultimately, I think under the AEDPA standard, this case really boils down to whether the post-conviction court's decision was objectively unreasonable. Whether it was so lacking in justification that there was an error well understood and comprehended in existing Supreme Court holdings beyond any possibility of fair-minded disagreement. And in this case, I think reasonable minds could disagree about whether Mr. Carica was sufficiently advised and whether he in fact knew of the potential sentencing exposure. Does the court have any other questions? Thank you for your time. We ask that the court affirm.
Thank you, Mr. Selly. Stewart, you have some time reserved.
Thank you. Picking up on the credibility finding, that stems from the PCR court's finding that the sentencing court made it clear to Mr. Carica that the guidelines are advisory only. That is unsupported by the record. And the PCR court found that Mr. Carica, quote, knew damn well what he was pleading guilty to. Nothing in the record suggests that. Also, it's an objective standard. It's whether Mr. Carica, someone in Mr. Carica's position would know that his sentence was 90 years, and that is not the case here. And I wanted to explain the case Austin v. Plumlee, which says that this court does not afford AEDPA deference to a state court's decision when it makes an unreasonable fact finding. And that is the case here. This court should be reviewing the case de novo. And to pick back up on Chief Judge Gregory's point, due process is definitely a trademark of the Constitution, and we are arguing that Mr. Carica is entitled to his due process rights. He should have known, meaning the court, the state, or his defense counsel should have clearly explained to him what his sentence was before he entered his plea. I think, a few times we've looked at what happened at the sentencing portion of this, but again, Mr. Kirica had already entered his plea before he got to sentencing. And so the guidelines changed later on, and he still didn't know what his sentence was at any point in the record. And the whatever sentence language that we discussed a lot was also discussing probation and a suspended sentence. It was too confusing for a person in Mr. Kirica's position. He was a 22-year-old black man at the time who had learning disabilities and psychiatric conditions and several other things such as homelessness and drug abuse at the time. He could not have known that he was facing 90 years based on...
Did the record indicate that the fact-finding court acknowledged his learning disability, his homelessness, and those things?
At sentencing, yes.
No, I talked about it in terms of PCR, in terms of looking at the understanding of this plea agreement. There was none, were there?
There was none.
Just the expletive in terms of he knew, as you said, well. Yeah, that's in the record, yeah.
Correct.
Go ahead.
And I think it's important that we not focus on the benefit Mr. Kirica could have received based on entering his plea agreement. What's required of due process is that the record firmly show he was told his maximum sentence, and he was simply not. The word allocute in his plea agreement, that sounds like a legal term that a layperson should not be able to know. And if it is a term that they should know, Mr. Kirica would think they could get any sentence between 30 to 51, that the state might allocute for 51, but it never suggests that he could receive 90. Liable is also a legal term within the plea colloquy, and it is not what a layperson can necessarily understand, especially after hearing several times the guidelines range. And just to be clear on what the record shows, the sentencing judge never said the word 90. He said 30, 30, 30, as Judge Wen pointed out. And so at no point at the plea colloquy did Mr. Kirica believe he was going to get 90. The record is ultimately too opaque, and that's what makes it objectively unreasonable. And Hart v. Hansen, Hansen v. Phillips, and Jameson v. Klim found that as well. And if the court has no further questions, I will sit down.
Thank you, counsel. I note that you're a court opponent, and on behalf of the Fourth Circuit, I want to thank you so much for being here. And it looks like the Hoyas were well represented today and acquitted here. And thank you so much. We appreciate that. And also, of course, Mr. Maselli, your able representation of your client as well. We'll come down and greet counsel. Parker, when you're ready.
May it please the court, David Parker of Hunt and Andrews Kurth, and I was appointed in this case to represent the appellant, Miss Melody Schuler, and I appreciate the opportunity to be here today. I was specifically appointed to brief a jurisdictional issue concerning Federal Rule of Appellate Procedure 4A6. This is the rule that allows the district court to reopen the period to file a notice of appeal under certain circumstances. And the court specifically requested briefing on whether Ms. Schuler, quote, received notice of the judgment against her within 21 days of that judgment being issued. And the answer to that question is no. The judgment against her was properly served within that 21-day period, but it wasn't actually received by Mrs. Schuler because it was sent to an old address. And as multiple other circuit courts have held, FRAP 4A6 requires actual receipt and not just effective service. Now, given the importance of this court's jurisdiction, I'll also walk briefly through the remaining two requirements of FRAP 4A6, and I'll also address whether the district court properly exercised its discretion in reopening the appeal period. So I'll start with the question of whether Ms. Schuler received notice under 4A6. So the first place to look here is the text. That's available in full at page 6 of our opening brief. And what the text says is that the litigant must, quote, receive notice of this judgment within 21 days. So I think the plain language here is straightforward. Receive notice means that the litigant must actually receive notice of the judgment. Effective service of that judgment is not enough, and if it were, the rule would have said so. The rule would have said the moving party was properly served under Rule 77D. Now, multiple circuit courts by this point have confirmed that this plain language means what it says, and that it requires actual receipt. This is the WorldCom case in the Second Circuit and the Core Chin Lim case in the Seventh Circuit. Both of those cases have squarely addressed this question and held that effective service is not enough. This is further confirmed by the advisory committee's notes, both the notes to FRAP 4A6 and Rule 77D, which is cited in 4A6. But those notes distinguish between service and receipt in two different ways. So first, the notes say that the judgment must, the rule applies when the judgment is either not received or is received too late to basically meet the deadline. And then the notes cite to cases in which the notice wasn't mailed at all, but they also cite to cases where the notice was mailed by the clerk and not received. So that's a clear distinction between mailing the notice, which would be proper service under 77D, and actual receipt of that notice. And then second, the notes also say that the winning party is encouraged to send their own notice to help, quote, rebut any claim of non-receipt. Now, if the clerk's mailing of the notice was itself sufficient to satisfy the rule, there would be no need to rebut any claim of non-receipt in this case. So I think the advisor...
on the part, sorry, Mr. Parker, any obligation on the part of a party to keep the clerk and the court apprised of his or her address? And if so, how does that apply in this context?
Yes, Your Honor. Litigants do have that obligation. Rule 4A6, I think, provides them some leniency on that. That does enter the analysis, I think, here, but I think it fits into the court's discretionary decision to allow reopening. So whether the litigant received notice or not doesn't really hinge on whether it was the litigant's fault that they didn't receive notice.
If we agree with your argument that the court could reopen this district court did not explain that reasoning in the order for granting it. So it didn't consider this business of, whether or not she should have be at fault for not updating her address. So at the very least, even if we agree with you, isn't there a remand that should occur in this case for that purpose?
Sure, Your Honor. So I'll address both parts of that question. So,
I mean, when you deal with Judge Diaz, does that have an effect? And I guess to the extent, does it have effect in terms of the question of whether to open it or not? And I think that still is a legitimate question. How do you answer that question? Does it have aside from the fact if you do open it and he didn't address it, then we would send it back to address it. But in the initial determination of whether to even reopen it, does it have, is it a factor?
So, Your Honor, I think there's a lot there. I think the first thing I would say is that the district court's order is not clear on the district court's reasoning. It doesn't say whether the district court considered this factor or not. This particular rule, FRAP 4A6, doesn't require the district court to set forth its reasoning expressly in an order. And so the district court wasn't required to set forth its reasoning. Certainly, it would be better if the district court had. So remand is certainly an option in this case. But I would say that based on the record before you, Your Honors, that you can also affirm, because I think there's ample evidence here and ample factual circumstances that support reopening, and I think you all can affirm as well.
We get to the reopening on your argument dealing with what was received, the legal aspect of it, and then we look at the two other requirements and say, okay, they're there, but we don't address the question, and nor did the district court, of, well, what about the obligation to update their address? Why would that not be compelled to at least, I don't know how we affirm on that. That hasn't been addressed at all. How do we affirm on that question? That wasn't addressed at all.
Well, Your Honor, I would say that in most instances, the district court, when exercising discretion under the rules, doesn't have to show its work and explain its reasons. Certainly, that's a better practice, Your Honor. But there are, for example, certain other rules that do require the district court to set forth its reasons. One example that comes to mind is Rule 54B, which allows district courts to certify partial final judgments. Now, that rule specifically says that the district court must expressly find that there would be no just reason for delay of the appeal. And certainly a number of courts have held that that language in that rule that says express finding is required, that does require the district court to actually set forth its reasons. But in the absence of that, we don't have any evidence in this case that the district court didn't understand that this was a discretionary decision or felt that it was compelled to reopen the appeal period even though it didn't want to. So I think
When we are looking for an abuse of discretion, we need to have the reasoning of the district court. There's none here.
Your Honor, I don't think it's a per se abuse of discretion to not set forth your reasoning, especially when that reasoning can be apparent from the record, which I think it is here. As I said, I certainly think it's better practice for the district court to set forth its reasons, but I don't think it is per se an abuse of discretion, and I do think that this court can affirm. This court can also, of course, remand.
From the record, I don't want to overpress this. I'm trying to understand, well, what you're saying, then we can consider that and determine, well, was it an abuse of discretion for him not to have gone in this direction? Because we take it that she was at fault. She should have updated the address. How is that? Where is it in the record that makes that apparent?
So I think there are a few things, Your Honor. The first is that the notice of appeal that Ms. Schuler filed was only a few days late, and that there's no prejudice claimed from the other side from her brief delay in filing that notice. Also, she, in fact, mailed it. She put it in the mail before the deadline.
Those are good reasons. None of them in the record in terms of the court having considered that. That's the only point I'm making on that.
Sure. Yes, you're right, Your Honor. The district court did not set forth its reasoning. The district court did not cite to these.
No reason at all on that point, because it just didn't get there.
That's correct. Yes. But I do think, as I said, I don't think that's a per se abuse of discretion. I think this court does, can and should affirm. But if this court, feels the need to remand, that certainly is an option. So the other thing that I would say is that, this was only a few days late. She actually got it in the mail before the deadline. And, I think it's apparent from Ms. Schuler's filings below that this was an individual who was struggling with a lot of issues in her life. In addition, this was all occurring at the beginning of the COVID-19 pandemic. This is back in April of 2020. And again, there's no prejudice to the other side. The other side hasn't even attempted to point to any prejudice. So it's hard to see this. This seems like a very good case, setting aside the fact that she should have updated her address earlier. Other than that, I think all the factors, point to allowing reopening here. So on the abuse of discretion point, I'm only aware of one decision that has ever found reopening to be an abuse of discretion, and that was the WorldCom decision, the Second Circuit decision. That aspect of WorldCom was split, so there was a majority and a dissent on that issue. What the majority said was that it was confining its ruling to the, quote, egregious facts in that case. And there, the party was represented by counsel, unlike here where Ms. Schuler was pro se in the district court. The counsel failed to update his address for 2 years, and he had every reason to be aware of any problem because there were numerous filings being sent to his old email address. So the court held that the counsel exercised, quote, exceedingly minimal diligence. Again, the facts are distinguishable here. Ms. Schuler was pro se. She should have updated her address sooner, but she did actually, monitor the docket herself. She did discover the judgment on the internet, and she did promptly get it in the mail after that point. It just didn't get to the court in time.
Wasn't she a lawyer?
She did used to be a lawyer, and the record isn't clear on exactly when that was, but I think the record is clear that she was not a lawyer at the time of the filing of this case. Now, that certainly could be something that the district court could consider, but I think that kind of highlights why this should be a discretionary decision for the district court. The district court should be able to consider what the district court knows about the litigant and knows about all the circumstances in the case that led to this notice being filed a few days late. Now, the other side points to the fact that the district court granted Ms. Schuler's motion as, quote, unopposed, and they take great issue with that in their briefing. So the first thing I'll say is it was unopposed. I think really what they mean is that they didn't have a fair chance to respond to her motion. There's certainly some truth to that. So what happened was Ms. Schuler had put the wrong docket number. If you remember, the district court had split her case into 6 different dockets. So that was another factor that made all of this kind of confusing to a pro se litigant. And so she had the wrong docket number on the motion. It was actually filed on the correct docket to begin with, but then the clerk moved it to a different docket and then moved it back. But once they moved it back, basically the deadline for responding to that motion had already passed. But what I will say is that, when the clerk moved it back, the order did say that the deadline had already passed, but defendants made no effort at that point to move to file an opposition out of time, for example, which I think they would have had very good cause to do. There was 3 months, actually more than 3 months, between when the motion was filed on the correct docket and when the district court actually decided it. So they had ample time to move then. They also didn't move for reconsideration of that order after the district court issued it. And regardless, there's no requirement. The district court could have granted Ms. Schuler's motion without even allowing a response. So I think that's the discretionary piece. The other 2 requirements of 4A6, I think, are pretty clearly met here. The first one is that the motion be filed within 14 days of the litigant receiving notice under Rule 77. And as we just discussed, she did not receive notice under Rule 77 from the clerk's office in the mail because that mailing was returned as undeliverable. Now, the other side argues that she also received notice when she discovered the judgment herself on the internet, and that she didn't file within 14 days of that. The problem for them there is that Rule FREP 4A6 requires a particular type of notice. It requires notice under Rule 77D. And I think this also answers the question that they raised in their brief of, well, why is FREP 4A6 referring to 77D if FREP 4A6 is requiring actual notice and not just effective service? The reason is that it requires actual notice of a particular type, and that's the notice that is sent under Rule 77D. So when Ms. Schuler discovered the judgment herself on the internet, that was not notice under Rule 77D. As the rule makes clear, that requires formal notice, and that wasn't sent here. And then the last requirement of FREP 4A6 is that no party would be prejudiced by the reopening. And once again, the other side hasn't identified any prejudice that they've suffered. Again, they knew about Ms. Schuler's appeal within a few days of the jurisdictional deadline passing. And so I think that is another reason, as I've said before, why Your Honors can simply affirm here. And in fact, there was another case, Herman versus Lackey, in which Judge Gregory, I believe, was on the panel, where a litigant had, quote, no valid excuse for their failure to receive notice, but the court held that no party was prejudiced by the brief delay, and it was within the court's discretion to reopen the appeal period, and so the reopening was allowed there. And so I think, this case fits under that rubric as well. And unless this court has further questions for me now, I'll save the remainder of my time for rebuttal.
Thank you, Mr. Parker. Mr. Lindeman.
Thank you, Your Honors. May it please the court, Andrew Lindeman for the appellees, Michael Lawrence and John Stuke. As the court has already noted, there are, in essence, two different questions for the court to address. The first one is a construction of Rule 4A6 of the Federal Rules of Appellate Procedure. If the court agrees with the appellee's position on that, don't need to reach, obviously, the second issue, but the second issue would deal with whether or not the district court exercised discretion at all, because I don't believe, if looking at the order, there's any indication that discretion was exercised at all, but ultimately whether there was an abuse of discretion in allowing the reopening of the time to file a notice of appeal based upon the record and what was presented to the district court. Dealing with the statutory, well, it's not statutory, the construction issue initially, and of course that's what this court asked for a specific briefing on. Ultimately, in this particular case, the final judgment that was issued by the district court was issued on April 22nd, 2020. The very next day, the clerk of court exercised their responsibilities under Rule 77D and served a copy of that final order and the judgment on the appellant, and by mailing it to her last known address. I think it's very important for consideration in this case, both issues before this court, that this particular litigant, as Judge Diaz indicated, this isn't just your regular pro se. Clearly she had some legal training. The record doesn't go into the details of that, but she clearly was identified as a former lawyer, someone who did have legal training. But the bottom line is there were 5 different orders that had been issued over the course of this litigation. And again, specifically, civil action number 88, which is the one we're dealing with. The original case was broken up into 6 different civil action numbers, 6 different civil actions. So she would have received similar notices from the district court, from the magistrate judge in all of those cases. But in this case, she received 5 different orders over the course of time, reminding her of the importance to keep the district court advised as to an accurate address for her. So ultimately, on April 23rd, the judgment was sent to her last known address, and it was returned ultimately unclaimed. There was a second attempt made as well that was also unsuccessful. So the issue boils down to, on a motion brought to reopen the notice, the period to file a notice of appeal under Rule 4A6, the first element, of course, is whether or not there was receipt. And the rule, of course, doesn't define receipt as actual receipt. It doesn't define it as constructive receipt. And I think that's an important point. So that's part of the interpretation that's needed here. But there is a reference, obviously, to Rule 77D. And I think if you accept the appellant's argument, you essentially read the reference to Rule 77D out of it.
How helpful are the decisions of the 7th and the 2nd Circuit on this issue?
Well, and there I somewhat differ. I mean, obviously the first of those cases was the Lim versus Court Call case, the 7th Circuit case.
You say somewhat different. That's a South Carolina word for you absolutely differ from that Seventh Circuit because it's against you.
Well, where I take exception with Judge Easterbrook is in the opinion he writes this. He writes, Appellate Rule 4A6 does not mesh perfectly with Civil Rules 5B and 77D. Rule 4A6 talks a receipt of a document under Rule 77D, but Rule 77D and 5B concern service rather than receipt. And where I differ from him is they both go to the point of notice. Rule 77D is a provision that obviously requires notice of the final judgment to be provided to the litigants. It also provides exactly how that should be undertaken. It specifically references Rule 5B, which again shows in this particular case that the method that the clerk used to provide that notice was followed. So it's not a question of actual receipt, it's a question of receipt, and that can include constructive receipt. And constructive receipt, of course, occurs given the references to 77D, which then references Rule 5B, that it is perfectly legitimate notice and ultimately constructive receipt for the judgment to have been mailed to the last known address.
Served, you're saying?
Well, again, the rules specifically rely on the service provision of Rule 5B. And I don't think that can be ignored in looking at how this should be interpreted.
The word received in this 4A6 reference instead of the word service.
Well, again, I think you look at what type of receipt it can be, and actual receipt is one type, and constructive is another. And I do think also, Judge Wynn, it's important to look at...
Constructive receipt in this case. It came back to the court.
Yeah,
Constructive receipt might be it was delivered to a neighbor. Well, but the neighbor got it and she found out that the neighbor is allowed to get her mail. That might be constructive, but it's documented that she did not get notice of the judgment against her.
Well,
Am I missing something? Is that right?
yeah, 2 points to what you just said, Chief Judge Gregory. It is not clear on this record as to whether or not she actually received notice. I mean, other than the envelope was returned to her, but ultimately...
Was it taped back up or something? It was the guy that went back, it was taped as if somebody opened it and then closed it and sent it back?
No, I'm not suggesting that. She ultimately did learn about the judgment being entered. She indicated it was on May 18th. As far as the point I wanted to make, though, as far as her address changing, that is not clear on the record. I mean, ultimately, it was returned. It wasn't necessarily returned because it was an improper address. It potentially was returned because it wasn't claimed, which is, of course, a different circumstance whatsoever as well.
But we can start with the belief that a Google search is not enough. I mean, that drafter's notes seem to indicate that. I mean, it has to be noticed under 77D.
Well, it does reference 77D, which again, if you're going to read 77D in it, you got to read 5B in it as well, because that's how the notice is provided under Rule 77D. It kind of goes back to my...
He handled Rule 5B. Do you remember his opinion when you look at that Seventh Circuit? He dealt with it. He didn't duck that issue.
Well, I don't believe he dealt with it correctly because he essentially reads 77D out of it, Your Honor. And of course, with that, you read 5B out of it. Ultimately, I mean, we've cited several different district court cases, which...
He distinguished the roles. He didn't read it out. He distinguished it as to what the purpose of 5B was as opposed to the rule here.
Well, I believe he was basically reading into this rule actual receipt as opposed to constructive receipt. And again, I go back to my original point that when you consider Rule 77D, which references 5B, constructive receipt should be sufficient. And the reason, and I was about to make this point a few moments ago, the reason I say that is you look at the intent of the rule to start with. The intent of the rule was not to allow somebody who didn't keep the court advised as to their address the opportunity to get a second bite of the apple or to correct their own neglect or negligence. It was to deal with situations where a clerk of court, for whatever reason, failed to provide service of the judgment to a litigant. That's the purpose of the rule. And even the Second Circuit in the WorldCom case makes that very distinction. And in fact, WorldCom, the Second Circuit does accept the Lim decision in addressing the three preconditions, but then they go further and say it still uses the word may, and a district court, even if the three preconditions are met, is not required to allow the reopening of the time for filing a notice of appeal. In those circumstances, you can still look at a number of other issues, and that's what the Second Circuit did. And they looked at, in fact, this is a key quote from the second part of their analysis. They said, we did not preclude district courts from considering the fault of a litigant that causes a failure of receipt. It would be curious, after all, not to consider indications that the litigant's own negligence caused the very problem that Rule 4A6 was meant to ameliorate. And that's exactly what we have here. So ultimately, even if you get past those first three preconditions, and if you agree with the way the Seventh Circuit interpreted them, you still have to deal with the discretionary decision as to whether it is appropriate to allow the reopening.
By definition, that means a discretionary decision. The district court could have acknowledged that there might have been some negligence on the part of this litigant, but excused it nonetheless. And so if that comes up, and I know the court's order doesn't say that, but aren't we supposed to, scour the record and decide whether or not this was in fact an abuse of discretion? And if the district court decided to grant relief notwithstanding the litigant's negligence, why is that an abuse of discretion?
Well, obviously that's precisely what the Second Circuit did. They ultimately found an abuse of discretion by the district court because the district court didn't consider the fact that the litigant themselves had caused this problem by not providing a current address. And in this case, it's the same situation. And in fact, the record in this case that was provided by Ms. Schuler doesn't even answer the questions as to what was her appropriate address when the judgment was issued. I would point out to the court that she makes some statement that she was evicted. There were no eviction papers that were provided. And ultimately, when she did serve the notice of appeal, which was a few days late, it was 4 days late, I believe, together with a notice for change of address at that point, it came from a Hinesville, Georgia address, while the original address of the clerk's office was here in Glen Allen, Virginia. So there's no record whatsoever that was provided to the district court as to what was her appropriate address, what happened to her, how she ended up in Georgia, when she got to Georgia. None of that has been answered. But to go to your point or question, Judge Diaz, we don't know from this opinion whether the judge exercised any jurisdiction. It's literally one sentence. She wrote, inasmuch as the court concludes Schuler meets the requirements set forth in Rule 4A6, the court will grant her motion.
Well, but I think what you're suggesting is that we should adopt a WorldCom rule, and any time a litigant is at fault, that's it. It doesn't matter what else might be in the record that suggests a district court could exercise its discretion favorably.
Well, I certainly think this court does have the ability to do what the Second Circuit did and look at the underlying facts of the case, what you're dealing with. The person was put on proper notice. As I've already mentioned, there are 5 separate orders in this case. She also caused a lot of these procedural issues by filing her what was ultimately treated as a motion to reopen the appeal time, she filed it in the wrong case, which ultimately caused my co-counsel in the lower court to not even be aware of the filing of this motion. The district court then issued a text order, but didn't issue it in this case. She issued it in the case with civil action number 1013, and it was never included in the record in civil action 88. So ultimately, there's a whole series of events here that were triggered by the plaintiff herself, who again is not your run-of-the-mill pro se litigant. It is someone with legal training, and obviously you can assess that. You can look at the complaint that was filed. You can look at, you know, the quality of her filings, and ultimately make that determination just like the Second Circuit did in WorldCom. But at the very least, the argument that I would make is if you agree with the appellants on the construction of Rule 4A6, at the very least, this court should remand so that we have an appropriate record made and appropriate fact-finding done. In fact, I would point out to the court that one of the cases that was cited in both briefs by the appellant is Nunley versus City of Los Angeles, a Ninth Circuit case, and this is the quote that was included in both briefs. It says, when a movement specifically denies receipt of notice, a district judge must make a considered factual determination concerning receipt rather than denying the motion out of hand based upon proof of mailing. Well, obviously, in granting a motion to reopen, that would also apply. A district judge must make a considered factual determination concerning receipt. And so ultimately, each of those preconditions should be addressed in the record to show that discretion has been exercised, because as this court said in the Jacobson case, an abuse of discretion can take place in several different ways, and one of which is when discretion isn't even exercised. It's not clear from the district court's order here, which consists of one sentence applicable to this particular motion, whether or not any discretion was exercised.
So I mean, in most of the cases that I'm aware of, when courts use that language, it's based on the notion and understanding from the record that the district court did not believe it had discretion to do something which it did in fact have. There's no indication in this record, is there, that the court exercised, well, you say it didn't. Are you suggesting that the district court thought it was obligated to grant relief even after, going through the initial analysis?
I do, and it goes back to the Second Circuit's decision in WorldCom, the second part of their decision. They make it very clear, the Second Circuit does, and I think they're right as far as that's concerned, and would encourage the court to adopt that portion of their decision, which is the use of the word may in the rule doesn't require a district court to grant that relief simply because the three preconditions might be met. You got to go the next step and still exercise discretion. And as the Second Circuit said, that additional analysis includes looking at whether or not the litigant, the moving party, is actually at fault for causing the failure of them to be able to receive notice, which clearly is at play here.
Isn't it in the record that she was at fault by not keeping her address current?
Yes, I think the record is clear that she did not keep her. Don't
we presume that the judge looked at everything in the record?
I don't think you can presume that from this particular order. And
No, I said the record. I didn't say the order.
No,
Was it in the record that it was returned, not delivered?
That was in the record. Now
that means that okay. And wasn't it also in the record that she didn't keep she had not, not kept her record, her address current? You're saying the court didn't know that?
Well, Your Honor, from the order, we can't judge what the court actually looked at.
Record.
Yes, the record reflects that she filed a later change of address.
The court knew that she had not kept it current.
Well,
correct?
The court couldn't determine.
The court knew she was not current. Can you just keep that, counsel? Can we get that first before you go?
Right. I don't believe that's necessarily correct, Your Honor, because.
Not necessarily. What do you mean necessarily?
Because
excuse me. we make it, as Shakespeare would say, much ado about nothing now. The point is, it's pretty clear here that they did not deliver the notice which was served. She didn't. And also it's clear that she did not keep her current address, fresh with the court. The court, that's in the record. And then the point is the judge knew that. And the judge says, I found those others. It didn't say I'm required. It said, haven't found those. This is my order. You disagree with that, and I appreciate you doing that. But what do they have to do? I mean, it's almost like Simon says, well, I see these, and I have to say, and Judge Diaz, is a question from that's my understanding too. Normally when we talk about discretion is when the problem is you think you can't do something and say, well, from this record, there's no indication that you were aware that you could have done it, but you chose not to. But now you're taking it in a positive way and saying, well, you have to show, what do you have to show that what do we have to do? Take out, well, I found this one and I think that's good. I found this one, I think that's good. Here, and then notwithstanding she has some fault, I grant it. Does he have to, or she has to say that, the judge?
Well, Your Honor, and again, I'm relying also on a case that they have cited from the Ninth Circuit. I think
you're in the Fourth Circuit now.
I understand that.
Okay.
And I believe
that is precedent, so we're here now.
I understand.
And we know you don't like the Seventh Circuit anyway.
I see my time's up. Can I have additional time to
You're in
answer?
good shape. I'm asking you the question.
All right. Thank you, Your Honor. Yeah, I think, Your Honor, ultimately the court should issue findings on each of the three preconditions, number one. And then number two, even if she finds that those preconditions have been met, needs to take it a step further, as the Second Circuit found, and address whether or not the neglect of the moving party played any role whatsoever in the moving party not being able to receive notice of the judgment.
Put a pin in that. Okay, let's say you take that step you said, and they find that her fault or her negligence did play a role. Are you saying that the court still does not have the discretion to grant that motion?
The court would still have the discretion to grant that motion, but in this particular case, there's no indication whatsoever in that one sentence disposition of this issue that the district judge even knew that that was the standard. And that's similar to what ultimately was the criticism of the Second Circuit had for the district court in that case, that they treated the proof of the three preconditions as essentially an entitlement to reopen without looking at the fact that the permissive word may is used in the rule, and that ultimately there's a second phase, so to speak, of discretion that needs to be exercised. And so ultimately, that's how the Second Circuit decided this case. Obviously, that's one of the principal cases appellant is relying on, and there's no indication that the district judge in this case, I mean, she didn't cite any case law either. There's no indication that she was aware of that and exercised that second layer of discretion. And a failure to exercise discretion, obviously, as this court has held numerous times, is an abuse of discretion. So with that said, we would ask that this court ultimately find that appellate jurisdiction is lacking in this particular case because the notice of appeal was not timely filed and it was inappropriate to reopen the time for the notice of appeal to be filed. Thank you, Your Honors.
Thank you, Mr. Lindemann. Mr. Parker, you have some time reserved.
Yes, Your Honors, I'd just like to address a few points here. So the other side basically only has one criticism, from what I can tell, of WorldCom and Chin Lim, and that is that they read out the reference to Rule 77D in FRAP 4A6. That is simply not the case. The purpose of that reference is to require a particular type of notice, but then the rule further says that that notice has to be received. So that language about Rule 77D was actually not always in the rule. It was added to the rule to resolve a circuit split over what type of notice was required. Was it formal notice? Was it the clerk mailing the judgment? Was it enough that the litigant learned about the notice on its own? The addition of Rule 77D settled that and required formal notice, but the rule separately requires receipt. So I think that issue is fairly clear. The other point about receipt is that the other side has said that it's not clear whether the mailing was actually received by Mrs. Schuler and just not opened, or whether it was returned for some reason. JA 138 shows the envelope that was returned to the court, and what it says is return to sender, insufficient address, unable to forward, return to sender.
That's what I thought too. Go ahead.
So I think that's clear. Now, as to the other side's argument that the district court should have to go through every single one of these factors, set forth all of its reasoning, then additionally, I guess acknowledge that it has discretion, and then explain why it's exercising its discretion, and acknowledge the fault of the litigant. I mean, none of that is required by the rule. And as Your Honors, Judge Diaz and Judge Gregory have said, I mean, when this court has said that the district court failed to exercise its discretion, that's when the district court has somehow indicated that it believes it doesn't have discretion. So if the district court in this case had said, Ms. Schuler technically met all three requirements of Rule 4, but, I really don't like that she was at fault here and she didn't update her address, but, I'm constrained by the rules to reopen the appeals period, that's a totally different case. I think you have to remand in that situation. But in the absence of something like that, you have to presume that the district court knows how to read the rules and knows how to look at the evidence in the record, which I think is clear here and allows for reopening. The other thing I was going to say is that my friend on the other side referenced Nunley, this Ninth Circuit case that said you must make factual findings. Obviously, that's a different circuit. But also what the Ninth Circuit said after that was, it's going to be a rare case where you have an envelope that says it was returned as undeliverable. And obviously, if you have that, then the issue is clear. We do have that in this case. The issue is very clear that the envelope never reached Mrs. Schuler. So I don't think that is an issue here. And then I guess the last thing I would say is that counsel appears to have given up on the other two requirements of FRAP 4A6, which I think were clearly met here. And so unless this court has further questions, I would just ask that it rule that it does have jurisdiction over this appeal.
Thank you, Mr. Parker. As you said in the beginning, you're court appointed. We note that, and on behalf of the Fourth Circuit, we thank you for that. We depend on lawyers like yourselves to represent parties here. We thank you. And also to Mr. Lindeman for your able representation of your clients as well. With that, I'll ask the clerk to adjourn the court until tomorrow morning, and then we'll come down and greet counsel.
This honorable